Are you a podcaster? Maybe you've got that big idea and you're looking for a network to join. The multi-award-winning Ozcast Network can get your content to eyes and ears all over the world. Join now for the first month free, and you could be featuring this sound at the beginning of your podcast. Ozcast. Simply head to ozcastnetwork.com for details.
This Chogm thing, the big meeting in Samoa. It's quite good, terrific to all get together and talk. But now they're going to be talking about climate change. Tis a ringing.
Hello, Jeremy.
Professor, how are you?
Well, thank you. How are you?
I am fine. I wanted to talk to you this morning about this Senator Lydia Thorpe. Number one, her outrageous demonstration in front of the King, but also the... Are you there, Professor? I think it's going to be one of those mornings. Are you there, Professor?
The gremlins are in the system.
I think they...
He put us on hold or something.
No, I don't think so. Professor?
I don't think it's there.
No, maybe we have to call him back again. Yeah. And I guess the Professor would have something to say about this Chogm thing too. Apparently they're going to say that Australia and Canada and Great Britain have to cancel all our fossil fuel industries. Don't know what's wrong, Professor.
It was me. The first call lapsed. I then tried to phone you back, and I had you on hold on one line. So I turned off. I tried to turn off the hold, and obviously turned you off. I'm sorry.
No, not a worry.
We're right now.
Thanks, Professor. Yeah, what did you make of the outburst of Lydia Thorpe?
Well, I thought that what she did was unacceptable. It was a serious breach of privilege. She behaved in an insulting way to the King, and she became a public embarrassment for the Senate, for the Parliament, and for the nation, and not only in Australia, but around the world.
She doesn't seem to have any shame, does she?
She doesn't, and she is serving no good purpose. She came into Parliament under the endorsement of the Greens. She withdrew from that, and she now is not performing, I think, any significant role. She's not fulfilling her role, and she now has admitted that she has, in fact, she fraudulently swore the oath of allegiance. She says so herself.
But she did also have to sign, so whether she fudged the word, as if that would make any difference really, but so she fudged the word which in her mind got her off the hook. So she, in her mind and her heart, she wasn't swearing allegiance to the Queen and the heirs and successors.
That is what she has now claimed. However, this, I believe, is a matter for the Senate to handle. In fact, I think there's an obligation on the Senate and on the government to resolve this matter and to ensure that this doesn't occur again. And she has herself cast doubt on her oath of allegiance. I think it is open for the Senate to consider this and to resolve a solution on this. And I think if they were to resolve, and it's open to them, I think, to resolve, if they were to resolve that she did not, in fact, swear the oath of allegiance, they could, in fact, it was an affirmation, as I understand it, not an oath of allegiance, but an affirmation of allegiance. If she did not do that validly, that is a matter for the Senate to decide, and it is open to them, I believe, to decide that the seat is now vacant.
Professor Les Elekes with Jeremy at the dining room table. I understand there's a third part of this process. She, because of her salary and the potential that she could lose her position and salary, she has come out to say, to try to disguise the second part that she, did make the affirmation, as you call it. Last night on Sky, Bronwyn Bishop mentioned, I think, a section 42 or 48 under the Constitution which could be used? I'm not sure exactly which one. Is there a particular section under the Constitution that she could be ousted?
My recollection is that in relation to privilege. Now, there's no specific provision which says she can. The section originally said that the privileges of the House of Representatives and of the Senate were the same as that of the House of Commons at the time of Federation. That was in the Constitution until the Parliament decides otherwise. Now, they decided otherwise in 1987. I think they made a serious error, which was, I suppose, open to them, but that happens when everybody is unanimous, including the advisors. They took away the power to expel for breach of privilege. And I think it would be open to them to restore it, but then there would be questions as to whether this could only relate to a breach of privilege after the restoration. I don't think that is the way in which they should go in relation to this particular matter, but I think they should draw conclusions from the fact that they did take away that power without thinking through it. And that is a matter about which politicians should be careful instead of rushing into these things. In any event, the question is what they can do now about what has recently happened, and not only on that occasion, on previous occasions in the Senate, when, for example, she first attempted to change the oath or the affirmation of allegiance, in which she tried to refer to the Queen as the colonizing Queen. I think if I recollect correctly. Yes. Now, it is still a matter for the Senate, and there's an obligation on the senator and all senators. This seat in the Senate, if it becomes vacant, will need to be filled by a member of the Greens party. That's in the constitutional provision. When the Constitution was changed after the dismissal, you might remember, on the initiative of Malcolm Fraser, the Constitution effectively provides that in the event of a vacancy, it must be a person of the same party as they were at the time of their election.
That's ideological.
Who would fill that position. And that's what was adopted and was agreed to by the people, and that's the Constitution at the moment. Now, I think it is open to the Senate to declare that the seat is vacant, because the Senate could find, and it's a matter for the Senate. I don't think it's a matter for the courts, although courts sometimes do move into areas which are intended for other parties. It is clearly under the Constitution a matter for the Senate. It's for the Senate to determine, and the Parliament, to determine what are the privileges of Parliament, but they are already there. Parliament already has and the Senate already has a function of looking at these matters, and the Senate has a function, I think, of deciding whether they have had a member there for some years who did not make the oath of allegiance.
Yeah.
Did not swear or make the affirmation of allegiance.
Or didn't want to. Really, in her heart of hearts, she didn't want to do that. But
you are putting your finger exactly on it, and that is that she had no intention to swear the oath of allegiance. Doing something like swearing an oath requires both the intention and the act. I mean, if you're, for example, a traitor, and you in wartime, but you still swear allegiance to the sovereign, and you commit some treason, then of course you commit that treason, and you are liable for it because your oath of allegiance is obviously fraudulent, and you've demonstrated that.
Professor, does the Senate have to deal with it, or can they just sweep it under the carpet and carry on?
They don't have to deal with it legally, but they have to deal with it morally and ethically. It is their duty to remove this embarrassment, to stop this embarrassment. The nation is we have been dragged through the media, the world's media.
Yes,
we've been made fun of it. People are thinking, well, what's wrong with Australia? What's wrong with Australia is that they tolerate this hooligan in the Senate. She is a hooligan. That's what she is, and she should. She's not behaving. as
but
a,
Professor,
a member of Parliament.
Is there a flaw in the Constitution in that it's happened numerous times that someone who's elected under a particular political banner suddenly decides to abandon ship, become an independent or change parties? Isn't that a flaw in the system, that if you do that after being elected, that you're not actually doing what you were elected for, and that there should be like an automatic
by-election
expulsion?
Yeah.
Well, I don't know about that. That's a matter for the Parliament and the people to decide. If you go back into history, there have been plenty of occasions. Lyons, for example, Joe Lyons, who was the Prime Minister of Australia, who had been a member of the Labor Party and switched to the Conservative side. We have William Morris Hughes. Winston Churchill was a member of about 5 parties.
Really?
The parties are not... We don't need parties. I don't know whether that was a good idea in relation to vacancies, to insist that the person not only be a member of the party but remain a member of the party at the time of appointment, so that the politician doesn't do what Joh Bjelke-Petersen. Remember, Joh Bjelke-Petersen filled a Labour vacancy by finding a member of the Labour Party who wasn't happy with the Labour Party. Yeah. Not Gare. He was a furniture polisher. That's what I remember his occupation, but I can't remember his name. But Joe did it because he would, yes, and he wouldn't accept there was a vacancy. A Labour senator died. There was a vacancy,
yes,
and he didn't accept the nominee because it's the state parliament who fills the vacancies. He didn't accept the nominee that the Labour Party offered because he was a political enemy of Joe and he didn't like his politics. He said, "Look, give me 3 names and then I'll appoint one of them." And it was then a matter for the state parliament, completely at the discretion of the state parliament, but there was a convention that you appoint from the same party. And he warned the Labour Party not to make the nomination they did. They went ahead with that nomination. So he eventually found somebody in the Labour Party who didn't like Gough Whitlam, and he appointed him. Now, I think that we put too much power into parties, and putting that power into parties means that they fill the seat with the person that you may not want. Yeah. And there's too much power in the parties, and they've rearranged the electoral law. This is another matter. They've rearranged the electoral laws in this country to suit them. And the Conservatives have been just as bad as the Labour Party on this. So we've got this ridiculous situation where we're one of the few countries in the world which have compulsory voting. That's to save the political parties from being able to, or going out and persuading the people to vote, because one of the ways that you can indicate your displeasure is not to vote, yes, which they do in every other country, just about every other country in the world, I think, except Australia and I think it may be Belgium among the democratic countries. Of course, you have to vote. You used to have to vote in the Soviet Union. The law didn't say so, but if you didn't, you'd be in very serious trouble.
But was there an opposition? Was there an opposition that you could have voted for?
Oh, there's no need for an opposition because everybody wanted Joe Stalin.
Yes, of course.
The dictator. But this is, I think the solution, there is a solution in some countries, and that's the recall election. Give the people the power to deal with these things. In some countries, you have what's called a recall election. If a certain percentage, say 10% of the electorate, sign a petition, the signatures would have to be verified and make sure that these aren't just chonky registrations, which some of the parties engage in just before the election. These aren't really fake electors, and there are plenty of those. But that's the way they arrange some of the very close electorates, the marginal electorates. But that's another question. But I think you have to have a system whereby the petition would have to be verified. Yeah. And if you've got, say, 10% of the people saying, we don't want that senator, 10% of the state, or 10% of the electorate saying we don't want that politician, that person would be forced to an election. Now, where it exists in other countries, it's been always exercised with a certain degree of sense so that you don't get foolish attempts to challenge a person, but you do get them. And I think that the politicians should be accountable to the people, not just once in every 3 or 4 years, in what are often confected elections, in that the parties have arranged who the candidates are. And they've got the system of preferential and compulsory voting, which favours the main parties. I think the way to handle these things is to refer it to the people. That's the problem of people switching sides.
Why is the Senate's term so long? What is it, 6 or 8 years?
It's 6 years. In New South Wales, it's the upper house is 8 years. It's usually double. The upper house, when it's elected, is usually double that of the House. And the argument is, and it comes from the United States, the argument is that you stagger the election of the upper house so that it presents it comes from a different occasion, and you get different parties and interests than in the lower house. So it has to be different from that. And the way that has been worked out right from the American Revolution, because they didn't have a House of Lords. In England, the upper house is different from the lower house because it represented the peerage, the aristocratic hereditary peerage, and the bishops.
Yeah.
And Professor,
so they were different from the commons. That was the whole point of the system, but that doesn't accord with modern ideas. And the way to do it is the way you do it, particularly if you have a powerful upper house, as we do in Australia, you make sure that they're elected at a different time, so they get 6 years. But I think if we had recall elections, that would be the way to deal with the problem of people switching sides.
Yep.
The public doesn't like it, the public might like it.
What would we have to do to install that idea of a recall?
We made the mistake at Federation, and the Prime Minister of South Australia, actually, they were Prime Ministers quite often. The Premiers were both sometimes referred to as Premiers and Prime Ministers. The Prime Minister of South Australia, whose name escapes me, at the time of the Federation Convention, came to the convention with a plan to introduce citizen-initiated referenda.
Right.
As part of the Constitution. It was going to be in relation to new laws. If a law were introduced, his argument was that this could be done through a citizen-initiated referenda. And Deakin persuaded him that this wasn't necessary because Deakin argued that the same achievement, the same system was worked out through responsible government, that is, the government being responsible to the lower house. So that was a time when the lower house wasn't controlled by the party that won the election. And I think he had a very good idea, but it didn't even go into discussion at the convention. But I think one of our big problems is that we've given the monopoly of instituting constitutional change to the politicians. Yeah. And that they're always complaining that only 8 referenda of the many that they've put over 44, I think it's 40 something.
Yes.
They've always complained and say Australians won't pass referenda. The problem is the referendums are chosen by the politicians. And what are the last 2 referendums? Things that people didn't want. First, a republic, which we managed to defeat 45-55, and in every state and in 72% of electorates. And then we had this ridiculous voice, which is to introduce a system of apartheid into this country, where your rights would depend on your race. And naturally, the Australian people, when they woke up to that, voted by 60% and in every state against it. The politicians decide what referenda should go in relation to constitutional change.
And Professor, on the subject of systems and potential flaws within the system, one of the things that bother me greatly is that a number of senators who represent us or allegedly represent us are elected because of the quota system on so few votes, and it's not necessarily representative of the larger bulk of the population. And people
You're
like
so
Lydia,
right. You're so right. And this is the way in which they've arranged the voting system to favour the political parties. We don't have to necessarily, the Constitution doesn't require that the existing way in which we vote, above the line and so on, above the line is designed to ensure that the major parties are advantaged. And we could have a completely different system. We don't have to, it doesn't have to be proportional. It could be first past the post, but that might produce a peculiar result in a state. And we have so many senators because we have so many members of the House of Representatives. We have, there are large numbers of politicians coming from Sydney, for example. Why is that? Because the population is so large in Sydney. Why is the population so large in Sydney? Because of the immigration policy of the federal government and the fact that they won't do any development outside of the capital cities, so we're not getting the water where we need it. And we can't develop this country because the politicians won't allow it. They only allow ever since the Hawke government, dams have been virtually forbidden as a sensible activity of government.
Very hard to get anything done. Professor, I don't know if it made it up to the Sydney Morning Herald, but it was certainly in the Age during the week. Not many editorials these days in the Age, but there was one on, I think it was Wednesday, calling on His Majesty the King, King Charles, to apologise to Aboriginal people for European settlement. Now, I don't know if it was carried in Sydney, but I read it. I just could not believe such absolute left-wing garbage.
Maybe our Indigenous population would have been happier with Japanese or Asian settlement or Chinese settlement.
Well, certainly
it was going to happen one way or the other.
Yeah. Certainly not the Maoris. They may have eaten them. It is so ridiculous. There were, of course, many things which went wrong, but the British came with the best of intentions of any of the colonial powers in relation to the Indigenous people. Just the instructions, the royal instructions to Philip were such to negotiate and to treat them as the same as white people. And it was an excellent piece of instructions. And of course, you couldn't have a situation where people were living in another century in one part of the world. There was a time when our ancestors were also hunters and gatherers. If we go back far enough, we would find that.
Professor,
but the world doesn't stand still, and if one part of the world develops, when, for example, obviously the Chinese had aspects of some developments which were very interesting to the West, and like paper, for example,
and gunpowder.
Gunpowder, yes.
In your view, Professor, constitutionally speaking, where did we go wrong? Can you identify a point in history where we went wrong? Was
Australia,
it Mabo or Terra Nullius or?
I think we went wrong when we drafted the Constitution, and the founders, they were very well informed men. They were all men. They were very well informed men that they made a mistake. I think a serious error in making the final court of appeal, effectively the final court of appeal in relation to constitutional matters, though some could still go to London. Not that that necessarily would provide the remedy, but leaving the judges as the final interpreters of the Constitution and making the appointment of the judges, vesting the appointment of the judgment of the judges totally and completely in the federal government. Yeah. So it was inevitable, I think. Sometimes the word inevitable is overused, particularly in relation to a non-existent republic. But what they did, and they knew how bad a high court can be, because they had the example of the American Supreme Court, which was the trigger of the Civil War. And so they saw how bad a high court can be. And what happened was that they left the decision in choosing the judges to the federal government, not even to the parliament to decide, but to the federal government. Now, what would the federal government do? They would tend to appoint people who thought the same way. That is, centralists who saw everything through the eyes of the centre and not through the states. So what they should have done, at least, was rotated it among the states. Yes. I mean, for example, you've never had, and this will appeal to you particularly, you've never had a High Court judge from South Australia.
No.
Isn't that extraordinary?
I wish we had you running the country, sir. Thank you very much for talking with us. You've, again, given us a lot of your valuable time. I'm very grateful. Thank you, Professor.
It was a great pleasure, and thank you for allowing me to talk with you and to your audience.
Thank you, sir. Constitutional lawyer, Professor David Flint, ladies and gentlemen.
Are you a podcaster? Maybe you've got that big idea and you're looking for a network to join. The multi-award-winning Ozcast network can get your content to eyes and ears all over the world. Join now for the first month free, and you could be featuring this sound at the beginning of your podcast.
Ozcast.
Simply head to ozcastnetwork.com for details.